My name is Bruce Siegel, and I'm the coordinator of these webinars. And welcome. We have a very exciting year planned, and stay tuned. Hopefully, most of you are on our email list and get notification of webinars. But I just wanted to talk about the Senior Law Day Collaborative for a moment. We are educational programs that are offered to seniors and their families throughout Westchester. Like a lot of other initiatives, we were offering in-person programs, and now, of course, also offer one-on-one consultations with attorneys like Kadeen and Sarah, who'll be with you today, as well as financial planners and care managers. I just wanted to take a moment to just share our screen and give you a sense of just some of the fantastic resources that are available through the Senior Law Day Collaborative. You see upcoming events. We have this amazing publication called the Elder Law Q&A. We offered 25 webinars last year, all of which you can listen to the recording right here. We have resources for Spanish speakers, and I'm always reminded, most important, there's a great opportunity to click this Ask Us button, and then you can ask us a question, anything related to a legal or financial or care issue, and we'll make sure you get pointed and an answer from the correct professional volunteer. So our next webinars are listed down here. You can see them, and I think the next one is right there. But anyway, we'll have a very full list of programs listed. And at this point, I think Sarah's on, and I will be quiet and turn it over to her to introduce Kadeen. And I'm going to stop sharing my screen. Thank you.
Thank you. Hi, good morning, everyone. We have a very exciting program for you this morning. So I want to give a warm welcome to Kadeen Wong, who is an attorney with Kurzman Eisenberg in White Plains, and she has extensive knowledge on trust and estates and tax and planning for the future. So please give a warm welcome to Kadeen, and during the program, if you have questions, please enter them into the Q&A or into the chat, and we'll do our best to answer them live or respond to them after our program today. So Kadeen, thanks so much for joining us this morning.
Thank you, Sarah and Bruce, for having me. Thank you, everyone, for joining this exciting program. This program, we're just going to be discussing questions that you should be considering when thinking about your estate planning and going to sit with your attorney to discuss what your estate plan will look like. And estate planning can be a difficult thing to think about. It forces us to contemplate matters that will occur while we're living and after our own death. So it's a very complicated topic. We often make the mistake of thinking that estate planning is for someone else, someone who's older, someone with more money, someone with children, or even someone with a more complicated family situation, but definitely not us. We think it's always for someone else. However, everyone can benefit from creating an estate plan, regardless of their age or their net worth, as a will or a trust will give you control over where your assets will go after death. As I said, in this session, we will discuss the planning process and the questions you should ask your attorney so you can take the next steps for planning for your children, your pets, your financial accounts, your cars, your home, your collectible items, no matter what they're worth. So when building an estate plan, you may have a variety of concerns, including maintaining an orderly distribution of your assets. Also, the administration of your assets while you're living. These are all concerns that you may have. And managing your estate's flexibility while you're living. Reviewing estates that you have in common with other people or community property. considering assets that you have in multiple states, examining your small business assets, naming your children's guardians. So these are all things that you should be considering. So from all of those things, I have made a list of 10 things that we will be discussing this morning. And one is the common estate planning terminologies, ones that you will hear and you will be referred to at different periods of your life. What are your assets? What are considered assets? Protecting your assets. Who are your beneficiaries? Do you have to give to all your beneficiaries? Tax planning and choosing a fiduciary to help you manage those assets. Planning for incapacity while you're living. Probate issues, burial directives, and COVID-19 pandemic issues. Okay, common estate planning terminologies. So you'll often hear the word and see the words, these words in your wills, your trusts, and other instruments that you'll have for your estate planning, as your estate planning documents. So you see the word deceased. This is just a person who has died. And estate will include all your assets, your debts left by you after you've died. A probate estate, these are the assets that actually go through probate after you die. They have to go through the court and then onto your beneficiary after you die. So these are your probate estate and your probate assets. An intestate, this is where the person died without a will. If you've died testate, you've died with a valid will. You will hear the terms grantor or settlor. Just an individual who add assets to the trust. A trustee is a person or institution who manages and distributes another's assets according to the instructions in the trust agreement. You also hear and see the words incapacitated or incompetent. These are individuals who are unable to manage their own affairs, either temporarily or permanently, or they lack legal power because, for example, of age. So what are your assets? You'll have your tangible personal assets, and you also have real properties. So your personal property will include tangible and intangible assets. So this will include your furniture, your automobiles, equipments, your cash, your stocks, jewelry, your art, clothing, your business interests, limited powers of attorney or general powers of attorney, even your digital assets. Should be considered when you sit to speak with your attorney. Think about your artwork that you may have online on Instagram or Facebook. Think about your videos that you have on TikTok. Where do you want those videos and pictures to go after you have you're no longer here? For example, your executor or fiduciary, whoever you appoint to manage your estate, this person won't be able to access your online account without having authority to do so. Most terms of agreement that you sign when you sign up to Facebook and to Instagram only allow you as the user to access your account. You would need to speak with your attorney to make special arrangements for your executor to have access after you've passed on. You also have your real property. These are land and property that is permanently attached to the land. Also remember to discuss with your attorney assets located in other states or in foreign countries, and also discuss hard to value assets such as closely held businesses, mineral rights, any loans and notes that you may have. what are some of the instruments that your attorney will be discussing? Well, of course, you'll be discussing your last will and testament, right? Which is a written document with instructions for disposing of your assets after your death. You'll go through a will execution. It's very formal and has to be done by precisely. And then there are your trusts. You have your inter vivas trust. This is just a trust that you create while you're living. For example, a revocable trust. This is a trust in which the person setting it up retains the power to either revoke or to control certain assets within the trust, and is created during the person's life. So it's an inter vivas trust. Then you have an irrevocable trust. This is a trust that cannot be changed, revoked, or canceled once it's set up. There are also testamentary trusts that you could create, and these testamentary trusts are created under your will, and these trusts will only go into effect after death. So, and it does not avoid probate. There are also special needs trusts, and these special needs trusts will allow you to provide for a disabled loved one without interfering with government benefits. You'll also can discuss spendthrift clauses with your attorney. Spendthrift clauses protect assets in a trust from a beneficiary's creditors. Also discuss any business structures, such as limited liability companies you may be thinking about forming, limited partnership. These are all asset protection strategies that could be used and that your attorney will be discussing with you. And it would be good for you to begin to think about these things before you actually sit down and speak with the attorney, and you have some ideas of what you would like to do or where you would like the conversation to lead. Now, who are your beneficiaries? So there are your heirs or distributees. These are terms that you'll hear as you go through the conversation with your attorney. So the heir distributees are just the people who are entitled by law to receive part of your estate. You'll also hear and see the word issue in a lot of your documents that you'll be receiving from your attorney. And this typically means a person, lineal descendants. This will include your child, your grandchildren, your great-grandchildren, on down the line. You'll also hear the word beneficiary or alternate beneficiary, successor or remainder beneficiary. You also hear the word contingent beneficiary. These are all just persons or organizations you name to receive your assets if the first beneficiary you named in your will or your trust dies, or if they refuse to take those assets, they disclaim those assets. Inheritance. These are the assets you receive from someone who has died. You could disinherit a person. You can disinherit a spouse under certain circumstances. You can also disinherit a child. These are all things that your attorney will discuss with you, of course. Their spousal right of election, which we'll discuss later on. If you can't, in New York, you can't simply disinherit a spouse. They have a right of election to elect against your estate. Minors. So, of course, if you have minors, you'll be discussing guardians of your child. You'll be discussing legal guardianship, as well as physical guardianship of your child, distribution, and you'll be discussing distributions as well. And you'll see terms such as per capita or per stirpes, representation. These are all terms that you'll see, and they all have very, very specific meanings. And your attorney would be able to discuss with you the different ways that your assets can be shared amongst your beneficiaries. So these are per capita, per stirpes, representation. These are all just ways of distributing your estate so that your surviving descendants will either equally take a share of your property, or it goes down through the line. So these are think about how you would like to divide property amongst your beneficiaries. That's what you should be thinking of, right?
Kadeen, so we have a vocabulary question that just came in. So our participant wants to know the difference between an executor and a fiduciary, or if they mean the same thing.
Okay. We'll be getting to that, but I'll answer the question now. An executor, excuse me, here we are. Very timely question. Okay, so an executor is a person you name in your will to carry out your instructions. And an executor will be appointed by the court to manage your estate. A fiduciary is a broader term. An executor is a fiduciary, but a fiduciary could be, for example, the definition here, a fiduciary could be a person or an organization that acts on another person's behalf. They have very, very specific duties. They have to act in the best interest of the person. And they also have to be, they're legally and ethically bound to act in the best interest of the other party. So a trustee is a fiduciary, an executor is a fiduciary. I'm hoping that answers the question. Here we are. So choosing a fiduciary, this will be very, very important. This will be important because the fiduciary will be the person you choose to manage all your assets after you're gone, or in the case of a trustee and you've created a revocable trust or irrevocable trust, is the person that you put in charge to manage and control all of your assets. This person will need to possibly sell property, continue your business. They'll need to analyze cash flows. They'll need to pay your debts. They'll need to notify Social Security and other businesses of your passing. So this person is someone who's very responsible. And if you can't think of someone, there are also organizations that you may choose to act on your behalf. And we already went through this slide. So tax planning and tax apportionment is going to be a very important part of your estate planning discussion with your attorney. You're going to be discussing gift tax, estate taxes, generation skipping taxes, as well as annual exemptions, federal and annual exclusions. And currently, the federal gift tax, you're able to give $15,000 per person per year, and that is exempt from gift tax. New York State doesn't have a gift tax. And of course, the estate exemptions are extremely high. Most people fall into the exemption and not over, and that's a good thing for us. So the federal exemption right now is $11,700,000, and New York State is $5,930,000. And of course, it's set for inflation. Index for inflation. Okay, planning for incapacity. You'll see terms such as power of attorney and durable power of attorney. Also, you'll see terms such as durable power of healthcare proxy. These are basically the same thing, except with the word durable, it's valid for a longer period. Like, for example, for a power of attorney, it's a legal document giving someone legal authority to sign your name on your behalf in your absence. This power of attorney would end at incapacity, right? So if you become incapacitated, or you can't really, act for yourself or think for yourself, this power of attorney ends. But if it's a durable power of attorney, this durable power of attorney lasts through incapacity and it ends at death. Most people opt to do a durable power of attorney just because it gives more flexibility. Then you'll also have your durable power of attorney for healthcare. And this is a legal document that lets you give someone else the authority to make make healthcare decisions for you in the event that you're unable to make them for yourself. And as I said, it's also called a healthcare proxy or medical power of attorney. You also see healthcare directives. These are all similar terms that you'll hear. And of course, your live-in will, which is similar to the healthcare power of attorney, but the healthcare power of attorney gives your agent more flexibility to speak with your doctors and, to transfer your files, while your medical records, while your live-in will is a legal document that tell others what your personal preferences are for your end of life treatments. For example, if you do not want to be resuscitated, if you do not want breathing tubes, certain medications that you may not want. So that's what the live-in will would come in handy. The durable power of attorney and the durable power of healthcare are all separate documents that does separate things. And of course, the durable power of attorney in healthcare and proxy and the live-in will sometimes come as one document. Here are some probate issues that we'll be discussing. So your attorney would ask you, do you have property? Where are your properties located? You need to consider, in the first slides we discussed, well, do you have foreign assets in different jurisdictions? The reason why this is important to discuss with your attorney, excuse me, is because you also need to plan for those assets while you're aware of them and while you're putting someone in charge of those assets, that you don't want them to fall into your residuary where it could go to anyone, right? Well, not quite anyone, but you would want to talk to your attorney to discuss property that you have in other states or other countries, because you'll need to have maybe an ancillary probate or an ancillary administration within those states, or even maybe a different country, to actually distribute these assets, pay whatever debts that you may have in those different jurisdictions. So when you hear the word administration, this is just a court supervised distribution of an estate without a will. And it's also used to describe the same process for a trust after the grantor dies. So we'll use we're administering the estate, meaning we're opening up a bank account, we're retitling assets. These administration is kind of a broad word that does all of that. And it also includes a court proceeding where a person died without a will. An ancillary administration, this is where you do have assets somewhere else, and this court supervised as well, and if you already have those assets titled in a trust, say you have assets in California, but you live in New York, but those, maybe it's a home, but it's titled in the name of your trust, then you don't need an ancillary probate or ancillary administration because it's in the name of the trust and the trust agreement controls. And your burial directives. Now, what are your burial directives? A burial directive basically appoints a person or several persons to hold the power, or successive persons to hold the power to organize your funeral, and also the disposition of your remains. Maybe you want to be cremated, maybe you want a mausoleum, maybe you want it to be buried with your favorite cat. Maybe, you have all your different options. Some people like to put these burial directives within their will. We often advise against doing that because your will could be read a lot later after the funeral. And if it's read after your funeral, then your directives weren't followed. So we advise creating your burial directives as a standalone document instead of including these directions in your will for convenience. And we come to slide 10, the COVID-19 pandemic issues. Your attorney currently can remotely execute your wills, and you can also remotely witness your documents. There's no need to go into the office or for the attorney to come to your home. Of course, you work out whatever you need to with your attorney and to facilitate the proper and due execution of all your documents. But right now, for everyone's safety, the governor has executed an order allowing us to remotely execute and witness documents for everyone's safety and convenience. So that's it. If we have any questions, I hand it back over to you, Sarah.
We actually, Kadeen, we had a couple of questions that came in. I'm just waiting for additional questions to come in as well. So okay. The first participant asks, what about prepaying funeral costs with a funeral parlor?
You're able to enter into a arrangement, and once you're sitting with your attorney and you're going through your burial directives, you want to explain to them, there will be a section for you to explain, have you entered into a pre-arranged agreement? And the attorney should check yes. And that's in that section, you'll put the place and the lot and the areas that whatever directions that you want. So yes.
And if you're looking to do Medicaid planning, you just want to make sure that prepaid funeral agreement or pre-plan, that it's irrevocable instead of revocable. If it's revocable versus irrevocable, you can still move the contract to a different funeral home if needed, but you just can't get a refund on what you paid, because if it's revocable, Medicaid views that as an asset. So our next question asker wants to know, when you hire a lawyer for probate, what does that typically include? Such as, what does that lawyer do? What does it take to get letters testamentary? Or do those services include things like filing tax waivers, figuring out liens, and so forth?
Yes, that's a very good question. And an estate planning attorney would be able to help you with all of those things. When you first come into the office, and you would be bringing in the wills. If there is a will, you would be bringing in the will the attorney would be preparing the probate documents for the court, be submitting those documents for you. Once you get letters testamentary or letters administration, letters testamentary is where you had a will and that will was probated. The court accepted the will as valid and now issued to you as the executor. A letters testamentary, a certificate saying you're authorized to act on behalf of the estate. And in administration, letters of administration is a certificate also giving you the authority to act, but it's called letters of administration because there is no will. So the attorney will help you prepare those documents, submit them to the court for you, help you to get your letters testamentary, your letters administration. Once you have that, the attorney can help you to file for an estate EIN, which is employee tax identification number, which you'll use to open up an estate account. And your attorney will be able to walk you through these process. Also filing tax returns, estate tax returns. So yes, we'll be able to walk you through the whole procedure, the whole administration of the estate.
Thanks, Kadeen. And also when doing the estate administration, the attorney will do as much or as little as you ask them to as the helper to the person who's been appointed by the court in gathering the property, paying the bills, and ultimately distributing that property to those who are supposed to receive it under that person's will or by law through administration. So another question came in, and that question is, why use a revocable trust instead of an irrevocable trust? What's the difference?
Okay. A lot of people, revocable trust is a trust that you create. Both of them can be created during your lifetime. A revocable trust is where you retain some control over those assets within the trust. It's a trust where you can put in assets, you will take out assets, you can change, maneuver, you have more flexibility with a revocable trust. With an irrevocable trust, you now have no control over the assets you've placed in the trust. You hopefully have put someone in charge to manage, the trustee to manage those assets, but now they're no longer in your control, they're in someone else's control.
Thanks, Kadeen. And we will have a program solely devoted to this question because there's a lot of details with a rev trust versus an irrev trust. But if you're thinking about doing any kind of trust, the first step is to call an attorney who practices in the area of estate planning, who's a true trust and estates practitioner, and have a conversation about what your goals are. And they'll be able to guide you whether a revocable trust or an irrevocable trust is better suited to your goals and what they're planning for. So that initial conversation is really, really important, which goes back to Kadeen's first point, which is that estate planning is really for everyone. And that no matter what you say, that there's people with more money or people with more children or people with more this or that, it's really something for everyone. And it's a very important thing to move forward with, to think about, so your wishes are honored and followed by your loved ones or your friends at the time of your passing. We actually have a lot of questions coming in. So the next one is, how can I access the PowerPoint slides following this presentation? And we're going to post them by Friday on the seniorlawday.info website. We also posted that link in the chat, and this video will also be posted there by Friday, so the materials can be accessed as well. If you have trouble getting the materials from the website, please feel free to either reach out directly to Kadeen, or you can put in a question through our website on the Ask Us button. Make sure to include your email and we'll send those materials out to you. So our next participant asks, if you assign beneficiaries on bank accounts um, in, and investment accounts, is it necessary to hire an attorney if you're single with no descendants but have nieces and nephews? So I guess the question is, do I need a will if I have beneficiary designations on everything, no children, and have nieces and nephews?
Well, the person, the beneficiary designation would control Sarah in this situation. So whoever that person they have listed on the bank account as a person to receive. They're different. First of all, there are different types of bank accounts and of course different investment accounts. But if you have named someone to receive those assets after you pass, then those documents controlled. The beneficiary designation will control. And so it wouldn't pass through your estate. So those assets wouldn't need a will to govern their distribution. And it wouldn't go, I'm not sure, I'm not sure I understand the questions with the nieces and cousins.
Yeah, I think that the question asker should at least have a conversation with an attorney. We have a free consultation date coming up, so that might be a good question to ask on one of our free 15-minute consultations to get an answer very specific to their personal situation. Because if you own a residence or a co-op or some other sort of real property, you can't put a beneficiary designation on that. So it's a conversation that you should at least have with an attorney, and then decide whether or not to move forward with a will or if the beneficiary designations are sufficient. Our next question asker asks, is asset protection a normal part of estate planning?
It has become a normal part of estate planning, especially in estate with high net worth. It's basically at the forefront of our minds. Asset protection. We want to protect our assets from children, and we have things called spendthrift trusts, which we earlier discussed. And spendthrift trust allows you to create a clause to help you protect your child's assets from creditors that they may have. So that's one asset protection scheme that is often used. But there are various techniques used as part of the asset protection bracket. So this is a conversation that you would need to have with your attorney, and they would tailor it for your specific needs and how to protect your assets.
And one way to think about that is make a list of all of your accounts. If you own a home, whatever's in your picture, life insurance, savings bonds, annuities, retirement accounts, get it all down on paper and think, well, what is the total? And what do I want to happen to this stuff, if I'm no longer here? And then to have that conversation or that consultation with an attorney who practices in the area of trusts and estates. So suggestions can be made, and you have that conversation to think about how to treat each asset that you have. Or it could be something as simple, if you're just starting out in life but you have children, making sure that you've nominated a guardian for those children to protect whatever you have for your children if you were no longer here. Because that's one of the biggest fights with families if you don't have a will, is who's going to take care of your children. And of course, often with a couple, they always think it's their family. So that's another part of that asset protection conversation, even if you're just starting out. Our next question asker says, can you place someone on a condo deed or mortgage for, I guess, estate planning purposes?
Can you place someone on.
I guess, can the question asker place their niece or nephew on their condo deed and mortgage to avoid probate? I think that really depends on the condo, and it's something that would have to be investigated, as
Yeah,
well
the
as what the
agreement.
tax
You would need
implications
the
of
deed,
that would
yeah,
be.
and the agreement also. You sign the deed.
So that's a very specific question that would need to be looked into. Our next participant asks, when you have accounts with transfer on death designations or beneficiaries, I assume those don't go through probate, but am I correct that they also do count in the value of the estate for tax purposes?
Yes.
Okay, so the next question asker says, does a written document on a piece of paper count as a will if you suddenly pass away, or does all the documents have to be legal?
So a valid will, there's a proper execution for a valid will, and it would need to be, of course, a written document. It needs to be properly signed and notarized and witnessed. So there are procedures to go through. However, there are certain types of wills, such as holographic wills, there are deathbed wills. So this is something. What was the question again? I'm sorry.
If the person just wrote down their wishes on a piece of paper and then suddenly passed away, does it count
No.
as a will?
No. No. There are procedures that needs to be followed, and there are certain things such as deathbed will, but I don't think what they've described just on a piece of paper will cut it.
Right, and there's a lot of case law in this area, but if you write your wishes on the piece of paper, if it's not signed, if it's not witnessed, it hasn't followed the statute on wills in the state of New York, and that it probably will not be admitted to probate. And I suggest that everyone have at least a basic will if they're not able to designate beneficiaries on everything. But it's a conversation that should be between the person and their estate planning attorney, even if it's just a consultation, and then you can decide what to do with regards to what fits your plan the best. How long does it normally take to have an estate in New York go through probate if there is a will?
Sometimes it could take 2 to 3 years, sometimes even longer, depending on the complexity of the situation. For example,
just to get appointed, not the whole estate administration.
Oh, okay. Just to get appointed. Well, for currently during COVID or the COVID pandemic, the courts are trying very hard to work as efficiently as they can. And I think they're doing a good job. They're allowing attorneys to file probates online, like e-filing, and then submitting, the original wills. And so far we have been able to get letters back within the space of a month, 2 months, where the executor can now begin opening up an estate account, marshaling all the assets of the estate, applying for an estate tax identification number. So we have been able to get letters or authority for our executors to act within a month, 2 months, but it all depends on the situation.
Exactly. Thanks, Kadeen. So our next question is, if I put my condo in a revocable trust, should I notify my homeowner's insurance of the change of ownership?
That's a very specific question. I'm not sure. I would need to see we would need to see the homeowners insurance guidelines and specifications to see what their requirements are. So that's a very specific question as well.
Exactly. We have to look at your policy And the answer would be, if it's not defined in your policy, yes, you should have that conversation, because if something should happen and the title is not correct, then the homeowner's insurance policy may not process the claim. So it's important to always double check that when transferring property. Okay, if anyone has any additional questions, please put them into the Q&A or the chat now. And
Sarah, while we wait for that, I just wanted to take a moment to thank our sponsors of the Senior Law Day Collaborative. Without their support, we wouldn't be able to make these programs possible. So I'm just going to flash that on the screen so we can recognize them, and then we'll see if there's any further questions.
Okay, so this is a good question. Do letters testamentary expire?
Most banks, it will say valid through, but most banks will, and other places that you work with, will require you to have letters issued within 6 months. So they always want to have something that's current. So if you say, for example, if you have letters from, last year, a few years ago, you would need to ask the court to issue you new letters. And most banks and organizations wouldn't take those letters. They would require new letters.
But getting updated letters is not a big deal. You or the attorney you're working with, they purchase an updated certificate from the court. It's $6. You can get them generally same day, and you're able to satisfy the bank or the title company if you're selling real estate. The court, though, can revoke the letters testamentary if you forget to file your inventory of assets, confirming to the court that you paid the proper filing fee. And that's supposed to be filed like within 7 months of getting appointed. It's a 1-page form, and it always can be amended if the executor who's been appointed doesn't have their hands wrapped around the full value of the estate at that time. Yeah. So you shouldn't be afraid of probate or worried about the letters expiring. Yeah. Any other last questions? Please explain a trust that protects assets against severe illness or incapacity while allowing one to live in their home. So the question asker is asking about using an irrevocable trust and how that works.
Okay. Sarah, would you be able to talk about
Sure.
supplemental needs trusts and Medicaid planning? I know there's a whole issue, a program for that, and it's a very complex topic as well.
Sure. So if you're an older adult and you're looking for Medicaid home care in New York, the rules are changing as of April 1st, tentatively. And right now, under the old rules, you're able to create an irrevocable trust where you're not the trustee, you're not the beneficiary of the principal of that trust, to move real estate, to move assets into it, and to qualify for Medicaid once the non-retirement assets that are in your name are less than $15,900 in 2021. This sort of irrevocable trust allows you to live in the property and receive Medicaid home care. It also permits you and requires you to pay all the household bills for that property. And under the new rules for Medicaid, which are potentially set without further delay to take place on April 1st, transfers to anyone who's not your spouse or disabled child will result in a penalty period, a delay in which you won't be able to receive those sorts of long-term care services. And so right now is a good time to do that sort of planning. If the person is younger than 65 years of age, they can create a self-settled supplemental needs trust to protect those assets. So they're able to receive government benefits. Otherwise, if there's a disabled person in your life who is receiving government benefits and you want to make sure that they are not lost, then under your estate planning documents, you would talk to your attorney about doing a supplemental needs trust so that the money that goes into the trust upon your passing can help enhance that person's quality of life without reducing any government benefits due to them. So there's a lot of various planning options for someone who has a medical illness or a disability. And it's a conversation that should be had with someone who practices in the area of both trust and estates, but also in the area of elder law and special needs.
Right.
And we do have a full program on Medicaid planning that we did. We had David Sweet speak. It's on our website. He's in charge of the home care division for Westchester County. And later this year, we're going to be hopefully having a follow-up program on the new Medicaid rules and what to expect if Medicaid is being applied for as that long-term care plan, if someone needs home health aides in the home, or if someone it needs nursing home care. So any other, we have one more question that came in. Okay, so the question asker asks, does a trust absolutely mean that your estate does not have to go through probate?
No, because you could have created a trust under your will, and if the trust is created under your will, it still goes through probate. And also, if there are certain confusions with certain assets, or certain assets weren't really retitled into the name of, say, an irrevocable trust, then it falls back into your estate. So then your estate would then need to go through probate, and the courts would then be involved.
Yeah, so if you're using a trust plan, a trust is a document it's a separate writing, or it could be in a will. But if you're using a revocable trust or an irrevocable trust as your primary estate planning document, check and double check as you move forward with your planning, and every now and then, to make sure that you've retitled all of your assets into that trust. Because unless the assets have been retitled into the name of the trust doesn't own them, and your will would control them if you don't have a designated beneficiary. So things like life insurance should have a designated beneficiary, or an annuity, or you would want to make sure that your financial accounts, whether they're checking, savings, or brokerage with stocks, have been moved into the trust. Retirement accounts, of course, you have to own yourself because they're individual retirement accounts. But you just want to always check and double check that you have beneficiary designations on file with your bank. And if the bank,
you're updated. Yeah,
exactly. And if the bank does something like change the account number internally, you also want to make sure that your beneficiary designations have been moved over. And if not, to fill out a new form, because you never want to leave your family in the situation where you did do a beneficiary form and then the bank updated their account numbering system and that all the old beneficiary designations didn't get carried over, which happens from time to time. So an estate plan is this living, breathing process. And just like getting a checkup with your doctor, it's always good to have a check-in with the attorney, a quick call saying, hi, has anything changed? Or if you've read an article in the newspaper, or if you've heard anything in terms of rules changes, it's always good to check in and have that conversation. And, we're here to help. So I think we have, okay, so I'm going to take one more question and then we're about at time. So our question asker asks, when does the probate process end? Can you describe the life cycle of the estate from filing papers with the court to when the estate ends?
Okay. Similar to the question earlier, your first meeting with the estate planning attorney, if there's a will, depends on if there's a will or if there's no will. So that first dictates the conversation with your attorney, and from there your attorney will be filing the probate or administration papers with the court. They would be talking to the court for you. They would be filing all the necessary papers, sending all the notices to the beneficiaries to say, this person who died, your interest in the estate is such, the will is being probated at this court. And of course, if there's like will contests, if there are spousal rights of election, as we discussed earlier on in the program, these are things that the attorneys will be helping you through along with the court. After you have received letters testamentary or letters administration, you will now need to administer the estate. And that in itself is a whole bag of things, right? Because if, as complex as the person's life was, that's how much you'd be administering, right? So you'll be administering to make sure that you've marshaled all the person's assets. They could have had arts, they could have had collectibles, real estate. They could have had properties in other countries, as we discussed, or other states. So these are all things that you're marshaling, you're getting control of and possessing, those assets that may have been loaned out by the decedent before he or she dies. So now it belongs to the estate. So those are things that you'll be going through. You'll also be opening a bank account, an estate account for the estate as well. There'll also be releases of tax liens. There'll be escrow accounts that the attorneys will be able to help you to manage the whole process and go through these things with you, including filing for an estate employer identification number, speaking with the creditors of any estate, and all the myriad of issues that could come up just because you're dealing, like Sarah said, your estate is, and yourself, it's a living, breathing thing that grows and changes. And so the complexities changes along with the person. Yeah.
And we just had another question, is there any benchmark? I mean, I'm sure it's all over the place. It could be a year, it could be 5 years, but do you have any guidance about how long, typically a probate process lasts, for a not too complex estate? I don't know if either of you can give any guidance on that.
So the absolute fastest would be the statutory creditors period, which runs for 7 months from the day the person's appointed as the executor or the administrator. And that's the time period in which a creditor is supposed to file a claim with the estate. So that the very fastest you can close the estate is after that period has expired. And an estate is closed by filing an inventory of assets, and in some counties, an affidavit of completion, after all the beneficiaries have received their property. And of course, after all the bills and the taxes have been paid.
Right.
Good. All right. Well, I think we're a little couple of minutes past time. So I wanted to just thank Kadeen and Sarah again, and thank everyone for your patience and attendance, and have a great day. I'm going to end the meeting in just a moment.
Okay. Thank you, everyone. Thank you, Bruce. Thank you, Sarah.